Jackson Laboratory is a nonprofit biomedical research facility that has been a National Cancer Institute designated cancer center since 1983. The Jackson Laboratory has more than 60 faculty with independent research programs and over 400 staff members that hold advanced degrees such as a Ph.D. or M.D., etc. In 2021, Jackson researchers were supported by $65 million peer-reviewed research funding dollars. Our researchers have made significant contributions to medical processes, including bone marrow and organ transplants, stem cell therapies, and in vitro fertilization. In today's talk, we will discuss IP capture and protection considerations within research organizations. Our speaker today is Salmaan, who has conducted cancer research in graduate school while pursuing his law degree and has 15 years of IP-related law service and currently serves as the IP counsel for the Jackson Laboratory. And we will turn it over to him now, and he can give his presentation on IP capture, and we'll follow with a few questions and then discuss what we want to see in 2023 as a group. Thank you. So.
Thanks, Kurt. Yeah, just want to make sure, can everybody see my screen?
Yes.
All right, great. So, yeah, I've been chief IP counsel at JAX for about a little over a year now. My experience has been primarily in the private sector. I was a patent litigator and worked in patent prosecution for about 10 years in law firms before switching over to in-house roles at some multinational corporations before I made the switch over to JAX. This is my first nonprofit, more academic related position. So it's been quite a learning curve in terms of how things are done on the academic side, on the nonprofit side. So let me go ahead and get started. I'll be talking mostly through IP. My experience has been primarily on the patent side, but I'll be talking about some copyright related issues for software as well today. I know that that's probably something that may be of impact to this group. So IP basically refers to the rights the legal rights that people have in different types of inventions, in works of authorship, and also in things like trademarks, where you can identify the sources of goods. There's basically three different types of patents. Patents cover inventions. There's the utility patents that are covering useful processes, machines or articles of manufacture, compositions of matter, useful improvements of any of those things. And there's design patents that cover the ornamental features of an object. Then there's plant patents that are basically covering a new or distinctive plant that's found in an uncultivated state that reproduces asexually. And then trademarks. Trademarks basically identify the source of a product or service. There can be a name of an organization. That could be a logo. It could be a phrase. But anything that will kind of trace the origin of products or services to that source. There's copyrights that are original works of authorship that can be in the field of literature, music, art, or software code. And then there's trade secrets. Trade secrets can be inventions or any kind of secret information that has commercial value. So we'll be primarily talking about patents and copyrights today. So what is a patent? A patent, it basically is it gives the inventor the right to exclude others from performing a certain activity. This is a little counterintuitive. People often think of patents as, oh, if I have a patent, that gives me a right to do something. It actually gives you the right to exclude others from doing something. So it's basically a sanctioned monopoly for a set of years. And after that term ends, the invention gets dedicated to the public. It's sort of a bargain that you make with the public, where you get the exclusivity, and at the end of the term of the patent, the invention gets dedicated to the public. And so, like I said, it doesn't give the inventor necessarily the right to make or use or sell the patented invention. We can illustrate that in this example here. Say that there's an invention that's already out there for a particular type of technology. We'll say it's maybe a black and white television technology that's already out there. Someone later comes along and builds on that technology and makes a color TV. So they're using basically the invention that came before, and they made an improvement to it. Well, to the extent that the color TV technology is using the black and white tech, and that black and white patent is still active, it has not yet expired. The person who or the inventor who developed the color TV technology would not be able to practice their invention unless they got a license from the patent owner of the black and white tech, or they'd have to wait until the black and white patent expires. But you do have the right to keep others from making a color TV if you have the color TV patent, but you may not necessarily be able to practice it yourself. So that's just kind of illustrating the nature of a patent right, where it gives you the right to exclude. Now, the most important part of the patent is what you see at the very end. I've got an sample patent here. Which is, we got the front page on the left, and then one of the last pages on the right, where it's kind of hard to see, so I'll blow it up. It's the numbered part at the end, which recites the patent claims. Now, these numbered claims here, they specifically define. It's kind of the equivalent of describing a property parcel, where you're describing the metes and bounds, what exactly is covered by your patent. So that's what the numbered section is here is, and that's what is the most important part of any patent. So what is patentable subject matter? Well, it's anything that is, it has to be useful, basically have a known use and a concrete and tangible result, has to be new, not previously known by others, has to be non-obvious. And the obviousness is based on a standard of what would be known to a person of ordinary skill in the art. So if it's someone who, if the patent, the invention relates to something about genetics, it'll be somebody who works in the field. It'll be a geneticist. If it's in computational biology, it'll be somebody who is an expert, has expertise maybe in bioinformatics. So that's basically the standard that we're looking at. And so the non-obviousness part comes in where for a person of ordinary skill, the invention can't really be found in a single or a reasonable combination of publications to yield a predictable result. So if it's something that's described in a couple of different publications that a person of ordinary skill would be able to look at and easily figure out and in practice, then that would render the invention obvious. So so a patent cannot be an abstract idea. It can't be a law or a product of nature, and it can't be a scientific principle. So you basically can't try to get a patent on something that already exists. It has to have like an inventive contribution, has to have an inventive concept associated with it that doesn't already exist. You can't discover something for the first time. Like for a while, people were able to get patents on genes, but that was back when it was difficult to isolate genes. There weren't kits for isolating and sequencing genes, but now it's become a lot easier. So the law kind of shifted a bit there. So if it's something that already exists in nature, you can identify it, but that's not going to give you the right to get a patent for it. It's possible to get patents for software where the way a typical software patent could take multiple forms, where it could be a computer system or a process, or the process performed by a computer system. So I've got a few examples here of typical patent claims. The way they're recited, it could be a computer configured to perform actions A, B, and C, or a computer implemented method that includes the steps of A, B, and C, or a computer readable medium that configures the computer to perform actions A, B, and C. So the general rule for software patenting is that if there's an algorithm associated with it, that needs to be disclosed in the patent. Without that, if that algorithm is required to practice that patent or practice the invention, it needs to be included, because that's part of the bargain. You need to disclose the patent with enough, or disclose the invention with enough specificity to allow someone of ordinary skill to be able to understand and to practice the invention. So without including support like the algorithm, the patent could be held as or regarded as invalid. So the one of the most important aspects to getting a patent is making sure that you avoid an inadvertent disclosure. So when we talked about the some of the requirements to get a patent, the invention has to be new. That applies to the inventor's own work as well, and the inventor's own public disclosures. So if you publish something first, if you present on your invention, if you discuss it on social media, which is happening a lot more these days, that can render your well, that can result in the loss of rights. That's more of an issue internationally, outside the U.S., where they tend to be a bit more hard-nosed about disclosure requirements, where there's an absolute novelty requirement. If it gets disclosed anywhere at any time, then you lose rights in many countries outside the U.S. In the U.S., you have a bit of a grace period. You have basically 1 year from the date of the disclosure to secure patent protection. But you also have to be mindful of the fact that the U.S. also switched a few years back to a first-to-file system. It used, where we used to be a first to invent, where if you were the first person to invent, you would have rights to it if somebody else came along later and tried to claim it in a patent. If you show evidence that you invented it first, you would get rights to it. But we abandoned that some years ago, and now it's a first to file. So that grace period is become a little bit, a little less important now, because the most important thing is to get your invention on file as soon as possible, because if you sit on your rights, somebody might beat you to the patent office. So this all kind of goes to underscoring the importance, if there is a new invention, if there's something that that may be of value to your organization, to before publishing on it, before presenting on it, before discussing it outside of your institution or among your peers within your institution, connect with your IP or tech transfer team, disclose it, discuss what may be the best patent strategy or the best protection strategy, whether it's keeping as a trade secret, maybe keeping as maintaining as or securing patent protection, or maybe copyright protection. So we're not going to go through this slide in detail. This is just to illustrate that the patent process can be lengthy. From the time that you have the disclosure of the invention to the point where you can secure patent protection, that can take some time. Typically, it takes up to 3 to 5 years. There's some possibilities or options for fast tracking cases where you pay a little bit extra to get the case under a more abbreviated examination schedule, but typically it takes some time. So if time is of the essence, there's depending on what your invention is, or depending on what you're trying to get protected, you want to think about what may be the best method for protecting the invention. So if we're talking about software, it's good to have the strategic discussion first, just to figure out, well, what are you really trying to protect? Are you looking to just protect your right to practice the invention? So are you looking for freedom to operate, where if you just publish it or get it out there, that'll first, that would preserve that right? Are you looking for protecting, maybe you developed a user interface that you want to get protection for? Are you looking to exclude competitors from practicing your invention? What's the likelihood that someone could look at the invention and reverse engineer it? How difficult would it be to enforce? And if it's got an algorithm associated with it, is it something that you would be comfortable disclosing? So those are some of the questions to ask, just in terms of wondering, well, what do you really want to protect? Then also, and especially in the software space, it's important to understand what's the shelf life here. Typically, software tends to be very fast moving. Is it fast moving technology? Can you wait for a patent? Oftentimes the software could be obsolete before your patent grants. So that's a consideration. Is it worth putting in the money? Patents, pursuing patent protection can be a pretty expensive prospect. Is exclusivity important? Are you just trying to get the software out there to sort of establish a name for yourself within the community? So some other considerations to kind of wonder, well, to ask and ask of your tech transfer IP team as you're developing a strategy. And then some different options for protection is, do you want to pursue copyright protection? That would cover the source and the object code. And copyright protection, you don't have to necessarily register for it. The copyright attaches immediately when you develop the software. So you only really have to register for protection or copyright protection if you are planning on enforcing your copyright. So one thing that the copyright does not cover, it doesn't cover the functional aspects of a computer program. It'll cover the actual code itself, but it won't really cover the function. So if you're looking for system design, for the logic behind it, and those are getting protection for the functional aspects are something that you would have to pursue through a patent. If you're going to pursue a patent, well, I asked before, well, what's the likelihood that you'll be able to enforce it? Will you be able to know if somebody's using it? Will you be able to identify it? Is that something you really want to police or that you'll be able to police? Sometimes just having a patent can be a deterrent for other people to use it. They'll respect that right. But if it's something that's difficult to enforce, it may incentivize others to just use your technology, use your algorithm if it's very unlikely that you'll be able to identify that they're using it. Is it something that you want to be able to protect through a trade secret? If it's a trade secret, the main questions are, is it something that you'll be able to maintain confidentially within your organization? Will you be able to put in safeguards that'll prevent people from accessing it? How vulnerable will the software be to reverse engineering? Will others outside your organization be able to get into it, to see what it is, to basically replicate it? So other questions and considerations to take into account when you're trying to protect software. Open source has become an increasingly important issue. I've been doing more work on it recently. My work is mainly on other more garden variety inventions when it comes to compositions of matter, when it comes to methods of treatment for diagnoses and so forth, or for treating patients with certain diseases. But open source software is becoming more important, especially in the computational biology space. And so using open source software, it's less of a problem if the software is being used in-house. You're not distributing it outside. You're not selling a product that incorporates open source software in it. And there's some pitfalls though. If you're using open source software and you try to patent a product or software that incorporates open source, that can result in a revocation of that open source license. The whole open source community, they don't take very kindly to people. Well, the concept of patents or the concept of just having a monopoly on a certain area. It's a very free and sharing community, as anybody who works with open source knows. And so so on open source, if you're planning on distributing it, any software that incorporates open source, you have to be mindful of the obligations that come with it. And so the open source software will have a license associated with it. So you want to be mindful of what those obligations are. On these, some licenses are what we refer to as copyleft, where they give you the right to freely distribute the copies of the software and modified versions, but you need to really be careful when doing that because the copyleft licenses typically require the users to make the modified source code or the entire program, that not just the part that you're using, available to your customers. And if that's something that's going to be a problem, if that's something that if the other parts of the software are proprietary, you want to protect them, you want to be careful about using any open source that has a copyleft license. Then there's the permissive licenses that have minimal requirements of how the software can be distributed. It's mainly you just have to have the attribution of the comply with the basic requirement of including the copyright, who developed it, and so forth, and just kind of leave it there. So the most important thing is when you're working in an organization that uses open source pretty frequently, to track that software, to make sure your programmers understand what's okay to use and what's not okay to use. And it's helpful to basically have a list that kind of summarizes the licenses of the various open source softwares. If there's a new one that comes up, update that list. Make sure the programmers are aware of the obligations, what's okay to use, what should be and what should be avoided. So I wanted to leave enough time for some questions. So I'll stop there please feel free to ask me anything about patents, about IP, about open source to the extent that I can answer. I'm still a relative newbie in the space, but I've had to do some work in the area over the last couple of years.
Well, first, thank you, Salmaan. That was a great talk. Really appreciated all the information. It's really thought-provoking on all the different aspects that go into the choices that we make and how that trickles down to what our rights will be in the future concerning our work. And open it up. Anybody has a question about IP?
Correct. There is already a question in the chat from early.
I'm sorry?
I can just read the question. So I think
go
this was from Annalie. The question is, who decides if something falls outside the scope of what is patentable?
I'm sorry, one more time? Who decides? Oh, what's outside of the scope of what's patentable? I see. Okay, yeah. Well, that's going to be the best place to kind of figure that out is well, ultimately it'll be the patent examiner that'll make that determination, but that's hopefully a question that'll be addressed by your IP team or by your tech transfer team, where they'll take a look and they'll assess the invention. They'll be able to tell you, well, yeah, if it really rises to that level, if it's something that's specific enough, that that's described clearly enough to warrant going through the effort of drafting a patent application. So the first level of making that determination should be your tech transfer or IP team. And then that question will get transferred up to the patent examiner once you file your patent application, and they'll and sometimes you'll get some pushback depending on what the invention is and what the tech area is. For example, like there's been a lot of pushback in the field of diagnostics over the last decade or so, where before inventions that were related to diagnostics were going through pretty easily, but then there was a court ruling that basically said that, well, what's a diagnostic? It's basically an observation of what's already out there. It's something that exists in nature. You're not really bringing anything inventive to that, and so that really hindered or brought an abrupt I guess not an end to diagnostic patents, but it really made it more stringent to be able to get an invention in that area. But yeah, that's a long way of basically saying the gates for determining patentability are your tech transfer team, your IP team, then the patent examiner at the next level. But the way that you should think of it, if you want to, just know for yourself, if the invention can be made or used by others the way that you can describe enough detail so that somebody who's got a similar skill set would be able to make and use the invention, that would mean that it's likely ready for patenting.
Thank you, Salmaan.
Sure.
Megan asked if you had any thoughts or experiences in licensing data sets and what IP protection that would fall under.
Well, the data sets would probably fall under more under copyright. And I've been on the outside looking in on data sets. We haven't licensed our well, we've shared data sets out under maybe material transfer agreements. So you would own the you'd still retain ownership of the rights to the data, but if you're sharing it with a collaborator, so that's one way to go about it, to do it through an MTA or a material transfer agreement. data sets, I suppose they can be licensed. Well, if they carry enough value, they can be licensed out. But yeah, it'll be whatever. Very much on a case by case in terms of what the value is, what terms the prospective licensee is willing to live with. If it's something that's got enough value where they would be willing to proceed with the license, that's something that could be done as well. So yeah, always possible to enter it into a contract for almost anything, but data sets tend to be well, if you're the holder of the information, yeah, you're obviously that puts you much more in the driver's seat. If you're on the outside looking in, it can be difficult. If it's a data set that they're for like maybe histological images that can be incorporated into a software platform where you can apply artificial intelligence to be able to generate I guess an AI-based diagnosis, that's become a very hot area, and that's where the data has become very much more coveted. So organizations that at one time used to be more free about sharing their information are starting to protect it a bit more. They're becoming a little more. They're treating their data as more proprietary. They're not as free with sharing that type of information because they want to develop maybe their own AI platform to be able to do that diagnosing information. And they know that the larger the data set, the more robust the data set that you have, the more powerful your AI-based diagnostic is going to be. So, but yeah, again, a very long-winded response to the simple question that, yeah, you can it's possible to license data. And my experience has been more on as what I've just been talking about. In terms of data sets that are used for to be applied to like an AI platform to make diagnostic determinations.
Correct. I have a follow-up question, if there is.
Go ahead.
So far. So my question is there the procedures for going about the patents different for whether you are a national lab or you are a private institution or a public sector, or is the procedure the same?
Yeah, the procedure is the same. If you're a nonprofit, you're going to pay less. There's a discount for the filing costs and so forth, and a lot of times if you're using an outside law firm, they'll give you like maybe a discounted rate for pursuing it, so the cost will be less. But otherwise, the procedure is pretty much the same. If you're a public or if you're an institution that's making inventions with grant-funded money, though, yes, there's definitely something you need to be mindful of. There's reporting requirements that you have to do, and anybody who's been on an NIH grant or who's doing any work with NIH grants knows this. That there's every like on a regular basis, the grant the funding agency requires you to report on inventions that are developed with the money that they're providing to you. So that's the biggest difference between working in the private sector and and then on the public side. If it's federally funded research, you have to make sure that you include that information. That information gets incorporated into the patent application as well, so that the funding agency will have rights in that invention. You'll definitely have the right to make, use, practice, license, and so forth, but the funding agency will also have rights if they wanted to exercise them. The NIH typically doesn't, but the DoD certainly does.
We had planned I was working on a speaker from the tech transfer office at a university, and that fell through for me. So I was curious on this call, are there any folks on this call that are working in the tech transfer space or have some experience helping a researcher in this space? Please let us know. Because definitely in the RCD space, we're, lots of open source software. And I guess I had not thought about, I would have thought that open source software would be the opposite, that it would be easier with an open source software package to make that more, to move that to a transfer versus a proprietary tool. So I hadn't thought of that.
Yeah, and like I said before, it becomes more of an issue if you're distributing outside of your organization. If it's something you're maintaining internally, it's not going to be something that'll be as likely to raise red flags. But if it's something that you're distributing, if it's a platform that you're putting out there, if it's incorporated into a product, then you definitely want to be mindful of the obligations under the open source licenses. And most of the time, the license holders, they're not looking really to shut you down. They'll just, as long as you're not a serial offender, it's more just, okay, get your stuff into compliance and then move on, sort of a deal. You're not going to be like, at least in my experience, I haven't really seen any open source license holders to try to, they're not looking to like bleed you for any like financial damages. It's just get into compliance.
I'd like to take this time to thank Salmaan again. I don't think we need to grill him for 40 minutes of questions. He might send us a bill. I'm just kidding. Salmaan, we just want to thank you again for the presentation today, and we're going to move on to the community discussion part of today's talk. So,
good deal. All right. Thanks, everyone.
Drop off. Thank you.
Take care.
Great. All right, I'm not seeing any additional questions in the chat. All right, and with that, we have the researcher-facing track. We're going to be taking the month of December off, and we're always looking for new ideas in that discussion space. Did folks have any ideas that they would like to discuss with us? Are there any thoughts on another topic that we could be working on as a steering committee to bring some speakers in? This community is yours. We'd welcome that. If anybody has any particular ideas. Yes, and we see there's a comment in the chat here about how should compute and storage system administrators engage with the researchers who have a strong interest in copyright and patentable work. And that is something that I think as soon as you start to hear those kinds of things, communicating with making sure that the tech transfer office, I think most of our institutions have those offices and have those resources available to us. I know that the sooner a faculty member is suggesting that that's an avenue that they're heading towards, getting them to speak with someone in your office or at your university is very important.
Justin, I wonder if, to follow with that comment, I really don't know the answer. If, in cases like this, the data will fall into something like protected data.
Yeah.
The plan is, for the researcher to, to patent some of the information or some of the data that is being produced.
Right. Right. And generally that would fall back to the type of grant work that you're functioning under, the terms and conditions right at the beginning of a conversation. When you're doing research or whether you have controlled research, you will need to adhere to those kinds of standards, whether it's if it's not basic research, then you need to be working with your research office to make sure that you do have those proper controls in place. Oh, we've got a hand raised. Em?
Yeah, just to follow up on the question that I asked.
Sure.
So our research computing has implemented a so-called secure research environment for protected data and so forth. And I'm just wondering if anyone has already kind of extended that idea towards trying to support the needs of more entrepreneurial oriented faculty who, anyway, it's just an open question, and maybe they just go and do this kind of work on different resources. I don't know.
Thank you. Anybody have any feedback on that? I know that, I'm supporting and helping in that controlled research space where we're dealing with defense level work where it needs to be controlled because there's requirements in the award that specify restrictions on publications and scholarly efforts. Outside of that, it's not basic research, it's controlled. And so right from the beginning, those conversations need to be had, and you need to be documenting and storing and using your data in a different way than you would with open science and basic research, for sure. And building those pathways right at the award process is how you can get that data secured in a way that restricts the sharing and the external sharing and limits that and tracks it. All right.
Justin, do we still have the document open for the survey about the topics that people might suggest for?
Yeah, I can open that up and we can take a look at what we had in our recent requests. There was, I guess, one area that we were discussing and was around VR, virtual reality, and if there was folks that are using things like eye motion and eye tracking software and tools like that. Is that of interest to dive into that topic? We would, that's something that we could facilitate. That was one of the areas. Let me see if I can get my list up of the different ideas. The other one that was on that call list was also this idea of serverless technology. How do we utilize infrastructure as code, you know, from the researcher-facing side of things and the infrastructure? That was something that I thought maybe we could be teaming up with the systems track to discuss. Let's see what I had here. Let's see. This is what we have been working off of in the past, has been our responses. We've had 32 different responses that kind of focusing on supporting augmented or virtual reality tools in the research space. And we were kind of getting mixed results in that space for call topic ideas. There was also, let me see if I can navigate my list here. My questions that I had was tech support or tech transfer, the tips and tricks for ticketing. That was the other topic that came up within our steering committee. What tools are people using to handle requests from researchers to triage and manage tickets coming in? There was also this tech support for using, you know, what tools do people use in that customer relationship management space, that CRM space? Was that another topic area that people saw as another area? Those were the three topics: the kind of infrastructure as a server, or code as a service, or code as infrastructure, and tips and tricks in that CRM space and virtual reality. I think that's
Justin, Bureau, if I'm saying Bureau's name right, suggested a topic, how to license data and data sets. That would be of interest, and someone +1'd it. So
okay, great. Yeah, that would be a good follow-up to this discussion to take that a little deeper, and then that might give us more time too to get the tech transfer office to dive in and explain how they've worked with RCD professionals in the past to help researchers get through the tech transfer process. Great. Any other thoughts on things that are like, what's your biggest issue in your office right now? I tend to go back to my day job, and then when I can't when I'm working on a problem, you know, I'm like, hey, maybe we should ask the community to help us figure this out, you know, or what is the community doing in this space? So yes, Tobin's saying intellectual property and data. Great.
Justin, do you know if CARC is going to have any meeting going on during SC22? It's starting this weekend.
You know, there are some, I see that Patrick is here on the call, and there's other leaders in the CARC community. Is there any meetups that are happening? I have not heard of any at Supercompute.
I'm not sure. I actually have to go to the National EBSCOR meeting, so I won't be there. Maybe Dana knows something about it.
Oh, Dana,
Yeah, I don't know of any, but we can all decide right now to do something if you want.
I like it. Definitely be on the lookout for your CARC members when you're at that conference for sure. I know that as part of next month's during the slot for the researcher facing call next month, which is the 8th of December, and I'm diving into announcements here, but we are doing the end of the year party, and there will be a breakout room around what was learned at supercomputing. So that definitely is going to be well, you'll have an opportunity next month to maybe hear what happened at the conference. So it'd be great if you could join us next month. And Megan's saying on the onboarding topic, it may be good to deep dive into particular topics for each call. What did you mean by that, Megan? Okay.
Sorry, it was a second comment help.
Yes. So,
Okay.
So kind of looking at file management, naming, and data transfer, things that are
Yes.
yeah.
Those are just like, so I do more education stuff. So those are my examples. The
Right.
folks doing the more compute side will have different ones.
Okay. I like it. All right, with that, I will maybe, Annalie, I'll just hand off to you to kind of wrap this call up, and we'll give people some time back. Thanks everybody for being here. Go ahead, Annalie.
Yeah, thanks. Okay, well, I want to thank Salmaan again, although he's not here. But that was a invaluable presentation by someone with a lot of expertise. So hopefully we can get the slides shared to you all, because that was a lot of material to cover. For sure, but we were very grateful to him and to the Jackson Laboratory and for just getting that expertise presented today. So again, this session's been recorded, and we will send an email out with a link to that recording fairly soon. Look for that maybe sometime next week. I think tomorrow's a holiday for a lot of people, so give us an extra day. As Justin already mentioned, we won't have a researcher-facing call specific to researcher-facing topic in December, because that second Thursday of the month has been acquired for the People Network party, the holiday party. And that's a really fun event, actually. So be on the lookout for that that information, the link and how to attend. I'm told that I actually haven't been, but I've heard great things about it. It's very casual and meant for conversation and connection and ideation. And there are breakout groups. And
Annalie, there will be prizes and a
and prizes. Oh,
yes.
Okay.
So
like there's a breakout room for games. There's one for what do you want to see from the network. There's one for debriefing on supercompute, which is next week. So something for everyone, basically. So be on the lookout for that. And then we've already talked about suggestions for topics for future calls, but we're always open to hearing from you about that. So find one of us and let us know, and we'd be happy to tease something out. That would be great to do with you. And I think other than that, I just want to thank the rest of the steering committee for all the work putting this together throughout the year. And I guess I'll wish everyone a happy Veterans Day, and to all our veterans, thank you for your service, and happy Thanksgiving, because we won't see you until December.